United States of America versus DeMonte Kendricks, United States Court of Appeals, 11th Circuit, United States of America, Plaintiff, Appellee v. DeMonte Kendricks, a.k.a. DeMonte J. Kendricks, Defendant, Appellant, number 17-11076, decided February 8th, 2018. Before Rosenbaum, Julie Carnes, and Hull, Circuit Judges, DeMonte Kendricks appeals his sentence of 57 months imprisonment imposed after he pled guilty to one count of being a felon in possession of a firearm. His sentence represents a 6-month downward variance from the low end of the applicable sentencing range under the Federal Sentencing Guidelines Manual, USSG. Kendricks argues that his sentence is substantively unreasonable because the district court refused to impose a greater downward variance to avoid unwarranted disparity in sentencing between himself and his state co-defendant, and to account for the fact that but for Kendricks' honesty when questioned by police, his guideline sentence would have been lower. For the reasons that follow, we affirm. On October 1, 2015, Kendricks and his passenger, Martinez Antoine Arnold, fled a traffic stop and engaged in a short, high-speed chase that ended after Kendricks ran a stop sign, lost control of the vehicle, and hit a guardrail. The police apprehended the men after they attempted to flee on foot. But upon searching the vehicle, officers discovered a small amount of marijuana as well as a pistol and a semi-automatic rifle, both loaded. Later, investigation revealed that both firearms were stolen. In subsequent interviews with the police, Kendricks admitted that he owned the rifle and that he lent it to Arnold, who planned to use it that night to retaliate against a rival gang who beat him up. Kendricks also told police that the pistol was his and described an unrelated incident involving that firearm. Kendricks and Arnold were both charged in state court, but while Kendricks was also charged in an instant case in federal court, Arnold was not charged in federal court. After unsuccessfully moving in the instant case to suppress his statements to police, Kendricks pled guilty to being a felon in possession of a firearm. Both Kendricks and Arnold's state court cases are still pending. The guideline for the count of conviction was USSG 2K2-1A4B. For the sole count, the base offense level was 20 because the offense involved a firearm capable of accepting a large capacity magazine, the semi-automatic rifle, and Kendricks was a prohibited person at the time he committed the offense. The court added 2 points under 2K2-1B4A to the offense level because the pistol was stolen, and it added another 4 under 2K2-1B6B because Kendricks knowingly allowed Arnold to possess the rifle to be used in connection with the planned drive-by shooting, another felony offense under 3C122. More points were added because Kendricks recklessly created a substantial risk of death or serious bodily injury to another person when he fled from arresting officers in a high-speed chase and ran a stop sign before crashing. As a result, Kendricks' adjusted offense level was 28 before the subtraction of the 3 points under 3E11A and 3E11B because Kendricks accepted responsibility for the offense and assisted authorities by timely notifying them of his intention to enter a guilty plea. Thus, the total adjusted level was 25. Kendricks received 1 criminal history point for a prior conviction for shoplifting and possession of drug paraphernalia. Because Kendricks was on probation for that crime when he committed the instant offense, his criminal history score was increased by 2 under USSG 4A1-1D, resulting in a total criminal history score of 3 and establishing a criminal history category of 2. Based on a total adjusted offense level of 25 and a criminal history category of 2, the probation officer calculated Kendricks' guideline range to be 63 to 78 months of imprisonment. The government asked the court to account in Kendricks' sentence for certain conduct that Kendrick did not plead guilty to. For this part, Kendricks argued for a below-guideline sentence of 37 months imprisonment, arguing that Arnold initiated the instant offense. His prior criminal history was for shoplifting only, and his offense level was higher because of his honesty during his interviews with the police. Kendricks further continued that while he understood the court's reason for denying his motion to suppress the statements, a downward variance was appropriate to account for the circumstances under which the statements were made. The court declined to consider conduct for which Kendricks was not convicted and specifically considered his age, history, association with gang activity, and the seriousness of the crime. It then imposed a 57-month sentence of imprisonment with 3 years of supervised release. We review all sentences, whether within or outside the guidelines, for reasonableness under the abuse of discretion standard. United States versus Erie, 612 F 3rd 1160 1186, 11th Circuit, 2010, en banc. The challenging party bears the burden of showing that the sentence is unreasonable in light of the record in the 18 U.S.C. 3553A factors, United States versus Victor, 719 F. 3rd 1288. 1291, 11th Circuit, 2013. The district's court sentence must be sufficient but not greater than necessary to comply with the purposes listed in 3553A2, including the need for the sentence to reflect the seriousness of the offense and to promote respect for the law, the need for adequate deterrence, the need to protect the public, and the need to provide the defendant with educational or vocational training, medical care, or other correctional treatment. 18 U.S.C. 3553A2, Victor 719 F. 3rd at 1291. The court should also consider the nature and circumstances of the offense and the history and characteristics of the defendant, the kinds of sentences available, the guideline range, any pertinent policy statements of the Sentencing Commission, the need to avoid unwarranted sentencing disparities, and the need to provide restitution of victims, USC 3553A137. Section 3553A6 of Title 18 specifically directs courts to consider the need to avoid unwarranted sentence disparities among defendants with similar records who have been found guilty of similar conduct. Well-founded claims of unwarranted sentencing disparity assume that apples are being compared to apples, United States versus DeCampo, 573 F. 3rd 1091, 1101, 11th Circuit, 2009, quotation omitted. Thus, 3553A6 applies only when comparing sentences among defendants who have been found guilty of similar conduct. See United States versus Martin, 455 F. 3rd 1227, 1241, 11th Circuit, 2006. Emphasis in original, rejecting 7-day sentence imposed by the district court after that court considered that a more culpable individual had been found not guilty. Additionally, the need to avoid unwarranted sentencing disparities arise only in the context of federal sentencing. DeCampo 573 F3D at 1102, rejecting argument that federal defendant was entitled to a less severe sentence based on the sentences received by other defendants in state court. Comparing a state sentence with the federal sentence does not establish an unwarranted sentencing disparity, CID. Here, the district court did not abuse its discretion in sentencing Kendricks to a below guidelines term of 57 months imprisonment. Kendricks argues that pursuant to 18 U.S.C. 3553A6, his sentence is disparately high in comparison to his state court co-defendant Arnold. However, Arnold has not been charged or found guilty of similar conduct at federal court level. His only charges are pending in state court, so Arnold is not similarly situated to Kendricks for purpose of considering parity in sentencing. Cito Campo 573 F3D at 1102. Kendrick also argues that his honesty with police during questioning, in which he knowingly and voluntarily waived his right to an attorney, resulted in an enhancement to his. But while the district court did not expressly acknowledge its consideration of his acceptance of responsibility, the court reduced his offense level and sentenced him on the lower end of the sentencing range. So the extent that Kendrick's honesty may have resulted in an increase in his offense level, it was accounted for under the guidelines via a reduction in offense level. Kendricks did not carry his burden of showing that the district court abused its discretion in considering the 18 U.S.C. 3553A factors. For these reasons, we affirm Kendrick's sentence. Affirm footnotes. Kendricks does not challenge the denial of this motion on appeal. Kendricks was previously convicted on May 15, 2015 of felony shoplifting and possession of drug paraphernalia per curiam. So y'all let me know, bro. Do y'all think Yak Gotti is a rat? I mean, you just heard the audio. Maybe you need to replay it. But y'all let me know y'all thoughts. I'm going to give y'all my thoughts in the live stream tonight because I got to marinate on this one. In one instance, you dry snitched. In another instance, you just did a whole bunch of stuff. And y'all just let me know, man. Put y'all theories together. Leave a like. If you don't see this video at 1,000 likes, do your part and join the visionary gang. Man, look, we need more people with that bell on. Hey, we about 11,000 away from 100,000. I think what I might do is going to be fun for everybody. We're going to have a live stream open once we hit that 1,000, that 100,000. So y'all let me know, man. Let's run these numbers up real quick. Hit subscribe if you have not. But I'll let y'all know my thoughts on the live because something ain't making sense to me, bro. Y'all expect me to keep it real? Because you know that I will. I do this daily, baby. Check out the Nightly Nash podcast. Also, Street the Music Steady Nash if you have not. It's on all streaming platforms. Guaranteed you're going to find something you like. Probably like that overly thugging freestyle, or maybe something different. Let me know in the comments. We possibly shoot that music video.